Hey there, and thanks for watching. Now, a few weeks ago, I shared one use case for ChatGPT or GPT-3, the AI engine that makes work far more efficient. And that use case was building a macro in Excel without actually knowing how to code. And I thought, why not share a few other use cases for how I am actually using this tool on a day-to-day basis in commercial real estate. Now, in my current role at a multi-strategy real estate investment firm, I spend a fair amount of my time negotiating with lenders, negotiating with capital partners, negotiating with sellers and buyers. Also, there's a hiring element where I'm negotiating with potential future team members. And in any negotiation in commercial real estate, the first concrete step is to agree to business terms. Now, when I say agree to business terms, I'm really talking about the handshake deal. In the good old days, a handshake deal was just literally that, a handshake. In this day and age, a handshake deal really is memorialized in writing in a non-binding document. And depending on the negotiation, that document will have different names. So if it's with a lender, it might be the pre-approval letter. If it's between partners, it might be a memorandum of understanding or a term sheet. If it's between a buyer and a seller, a letter of intent. Maybe it's between a client and a broker in the form of an NDA, although an NDA and a confidentiality are binding. The point being is that we as business professionals, not as legal professionals, but as business professionals, often have to draft some language that will then eventually be memorialized in a binding document by attorneys. And so in the past, what I've done, say I have a letter of intent and I need some clause or I need a modification to a clause in a letter of intent. In the past, what I've done is either I will go to my library of past LOIs, I'll find some language maybe that was created there, or I might go to the internet and there's a lot of template LOIs, kind of scan through those, I'll find some language, I'll piece it together. It might be a 10, 15-minute process. Sometimes I can put a clause together in 5 minutes. Other times, if it's a more complex clause, it might take 15, 20 minutes. And I want to ensure that I'm not missing something. And again, these are non-binding documents, but the purpose of the language is to ensure that the business terms that we're agreeing to are complete. And therefore, when passed along to the attorneys, they can memorialize those complete business terms. And so let's take, for instance, a letter of intent. Let's imagine that I'm a seller and a buyer submits an offer. And in the offer, the buyer has a non-disclosure clause. And the non-disclosure clause is one-sided. Or in other words, it is, I as a seller agree not to disclose any of the information that the buyer provides to me. But look, I'm going to be sharing back with the buyer a lot of information. And I want this non-disclosure clause to be mutual. And so I want to counter the LOI, amongst other things, price and earnest money and due diligence period and so forth. But maybe I wanted to edit that non-disclosure clause. Well, rather than crafting some language on my own, I can come to ChatGPT. Now, what you're seeing here is the ChatGPT interface. My preference actually is to use OpenAI's Playground. Again, this is the same exact engine that drives ChatGPT. And the nice thing about the Playground is that I can actually modulate the outcome from the AI. But I'm going to use ChatGPT just because I think that's the more commonly known tool. And for these purposes, the results will largely be the same. So here in ChatGPT, I'm going to give the AI a prompt. And the prompt is in essence what I want. And so imagine you are telling an attorney what you would like the clause to say. I would say something like, draft a clause for a letter of intent that requires the buyer and seller to keep all information confidential. Okay, so I provide the prompt to the AI, I hit submit, and the AI is going to produce some clause. Both the buyer and seller agree to keep all information regarding the potential transaction, including but not limited to financial information, trade secrets, and any other proprietary information, strictly confidential, and shall not disclose such information to any third party without the express written consent of the other party unless required by law. Right, so now this clause is a bit more complete than what I had in mind, which was just simply, hey, neither of us will share anything that we provide. The clause lists some examples of information, and now this prompts me as the business professional to say, okay, I wonder if there's anything else I'd like to add to this list, even though the list is including but not limited to. It also stipulates that, hey, there may be information that either of us have to disclose by law. And so what ChatGPT has done is it's taken my very simplistic look and added some meat to it. Professionalism on one side, so the language is going to be a bit more legalese, and has prompted me to a few things that I may not have considered. So that's a letter of intent. Let's look at a few other examples. Let's say also in a letter of intent, but in this case, I'm on the buyer side. I submitted an LOI with a price, maybe a 30-day due diligence and a 15-day closing period, and some earnest money, $50,000, $100,000, whatever. And let's imagine that we get some verbal feedback. And oftentimes that's what happens is one party is drafting, the other party, for whatever reason, prefers not to respond in writing. But at the end of the day, we need something memorialized in a non-binding written document. And let's say that the counterparty, in this case a seller, comes back to us and says, hey, I want to change the price to X. I want to change the due diligence timing to Y. And I want to add some additional earnest money. So at the end of the due diligence period, you have to put up X amount of additional earnest money. Well, we have to now create a new clause in our LOI. And the clause is for an additional earnest money. And so let's go ahead and give the prompt. So draft a clause to a letter of intent where the buyer must deposit additional earnest money at the conclusion or at the end of the due diligence period. Okay, so just a simple prompt. Let's see what the AI comes with. So the buyer shall deposit an additional amount of earnest money to be determined by the seller at the end of the due diligence period. This deposit shall be made within 5 business days of the completion of the due diligence period and shall be held in escrow until the closing of the transaction. If the buyer fails to make this deposit, the seller shall have the right to terminate this letter of intent and retain any earnest money already deposited. So there's a few things that the AI has added. The first is the amount. See, the buyer shall deposit an additional amount of earnest money to be determined by the seller. Well, me as the buyer, I don't want that. I'm going to determine that up front. This is going to be an offer. So that would be the first thing I would edit. So let's update the prompt. Go ahead and copy this. Actually, let's just edit it. So draft a clause of letter of intent where the buyer will deposit additional earnest money of, let's say, $50,000 at the end of the due diligence period and shall be held in escrow. All right, so the buyer shall deposit an additional $50,000 as earnest money at the end of the due diligence period to be held in escrow by a mutually agreed upon escrow agent. This additional earnest money shall be applied towards the purchase price of the property in the event that the parties enter into a definitive purchase agreement. Okay, so this is closer to what we want. Now, the previous option or example provided a period, 5 days within the after the end of the due diligence period. It also was less defined around escrow agent. In this case now, it provides some language where it's to be held by a mutually agreed upon escrow agent, likely already had been defined within the LOI, and clearly defines the amount of earnest money, and says that the additional earnest money shall be applied towards the purchase price, which is an important piece to this. So I think that's good language now. I would take this, I'd copy it in my LOI, and now I have something to pass along. So that's a second example. Let's throw in one final example. Let's imagine we're drafting a Memorandum of Understanding, an MOU, between two partners, a GP and an LP. And the GP is initiating the MOU in request for a capital raise from an LP. And let's say that one of the clauses we will need is a decision-making clause. That's a clause that will define who has what authority to approve what. And so we're going to give a prompt, draft a clause to a memorandum of understanding between a GP and between two parties, GP and LP. Okay, yeah. The clause shall be named decision making and shall provide a list of the decision making, let's just say, requirements of each party. Let's see what it comes up with. So decision making. GP shall be responsible for, and then it gives us some examples, day-to-day management operations of the project, and shall have the authority to make decisions on behalf of the GP with regards to the project, including not limited to decisions regarding budget, timelines, and staffing. LP shall have the right to approve any significant decisions related to the project, including but not limited to decisions regarding capital expenditures and changes to project scope. Any decisions related to the project that require approval from both GP and LP shall be made by mutual agreement between the parties. So that's now a good start, right? It provides a framework, and then depending on what verbal discussions have been made, we might memorialize these things. So for instance, LP shall have the right to approve any significant decisions related to the project, including but not limited to. In this case, they give us some options: capital expenditures, changes to the project scope. It might be refinance and sale. It might be the investment guardrails of, say, maybe this is an apartment development, a programmatic apartment development partnership, and the GP will have some discretion, but within a box, and that box would be defined in, call it, investment guardrails. So now we have a clause that we can start with, and then use now more strategic thinking to fill in the clause and to finalize it. So anyway, those are, or that is another use case for ChatGPT in commercial real estate investing. I'd love to hear if you're using this tool in other ways in real estate. Drop those in comments below or shoot us an email. I'd love to hear it. And again, thanks for your time here.